Hello, this is Paula White with week 2 in Accounting 499. This week is all about working with attorneys. So we're going to have a couple short audios, pre-recorded interviews, and we're going to talk about the textbook, and we're going to talk about some other topics relating to the week 2 topic for 499. So let's get started. Give me a second here. This week, we'll be covering chapter 19. And just to give a brief overview, we're just going to page through it. I like this textbook. Chapter 19 looks like 10 pages, which isn't that bad to read for your textbook, and basically is how to support a criminal prosecution. It's very well written, and I think it's interesting. But I'm not going to read you your 10-page chapter. I'm going to kind of highlight a couple things. There's some key consideration, and you can read as well as I can, about deterrent effect of appropriate response, U.S. Sentencing Commission guidelines, and those include compliance standards and procedures reasonably capable of reducing the prospect of criminal activity. It includes oversight by higher level personnel, due care in delegating, substantial discretionary authority. It includes effective communication to employees at all levels, and it includes reasonable steps to achieve compliance, consistent enforcement of standards, including disciplinary mechanism, and reasonable steps to respond to and prevent further similar offenses upon detection of a violation. And then that was amended in 2004 to include both the guidelines from Sarbanes-Oxley and the emerging public and private regulatory requirements. And they modified that with 10 modifications. One is tone at the top. Emphasize within the guidelines the importance of an organizational culture that encourages a commitment to compliance with the law. I personally think that's an odd one because I'm a law-abiding citizen, and shouldn't that be part of the American culture? But it has to be tone at the top. The corporation culture at the top has to encourage a commitment to compliance with the law. Conduct and internal control. They're supposed to provide a better description of compliance standards and procedures, namely the standards of conduct and internal control systems that are reasonably capable of reducing the likelihood of violations of the law. How about leadership accountability? This specifies the responsibilities of an organization's governing authority and organizational leadership for compliance. Then we have resources and authority, and that's to emphasize the importance of adequate resources and the authority for individuals with the responsibility for implementation of those programs. What about history of violations? Instead of having the language be propensity to engage in violations of law, how about history of engaging in violations of the law? Conduct training, evaluate programs, add the whistleblower system, which is a mechanism for anonymous reporting. That's extremely important. Encourage employees. Establish a system whereby employees can both report actual violations and seek guidance about potential violations in order to more specifically encourage prevention and deterrence of violations. And of course, it follows up with risk assessment. Then we have expense and possible outcomes. How about referrals for prosecution may attract public attention? Well, you see that on the news every day. Referral considerations include whether or not the investigation is sufficiently advanced to make a reasonable decision about the nature of the suspected crime. What about the specific laws and regulations relating to the suspected crime or the industry in which the entities operate require of the company? Level of individual nature of the offense and whether or not the company's insurance coverage contains any clauses that would affect the timing of the referral. And the prosecutors must prioritize the cases. By being a forensic accounting investigator, that may increase the success of a referral. Reputational benefits. It can increase your reputation in the industry. You'll be involved with plea agreements, filing lawsuits, and we're about done with the chapter. So it's an easy read. It's 10 pages. And so what are you going to do with that 10-page read? So let's go to the home page. And look at week 2. Speeding right along here. Week 2, you still have the discussion. You have assignment on litigation, and then you have your weekly quiz, your assessment. So let's see what the assignment for litigation is, and it's a 1 to 2 page paper, APA format, and it's going to be in a Word document, and you're going to research a fraud case. You're going to submit a short paper on how the fraud was discovered and how it could have been prevented. And they've given you some sources, including some cases in the ACFE website. That's the Association of Certified Fraud Examiners, newspaper articles, magazines, and there's a few listed below just for your reference, but get a good, nice, juicy case, okay? Make it interesting for you and for me to read. And so that's your assignment, is to find a fraud case and write on it. How it was discovered and how it could have been prevented. I found an article in the AICPA website about the top 5 cyber crimes. And I thought they were interesting to share with you. See, this material is everywhere. And I'm not going to read it to you, but there's an executive summary, and there's 5 cyber crimes. And conclusion. Basically, the top 5 cyber crimes that we're going to discuss is tax refund fraud, corporate account takeover, identity theft, theft of sensitive data, and theft of intellectual property. So what's happening in these areas? Companies participating in a 2012 study suffered an average of 102 successful cyber attacks a week, up from 72 in 2011. I wonder what that same amount is in 2015. So what's going on with tax refund fraud? Well, and you can read this, but I'm just going to give you the brief overview. People have been able to get, or people actually file false tax returns. The first paragraph said that there's 3 defendants were charged with filing more than 5,000 false returns using the Social Security numbers of deceased taxpayers to claim fraudulent refunds totaling about $14 million. And that's in the issue of 2012 October issue of the Journal of Accountancy, which is a publication put out by the American Institute of CPAs, AICPA. So basically what these folks are doing, they are getting Social Security numbers from the deceased. They had to get their valid name and Social Security number. And it has to be someone who won't probably be filing a tax return. Well, if you're deceased and you don't have an estate, really, you'll probably not be filing a tax return. So basically, this information is sold on the black market and has some degree of access to the necessary personal identifiable information: name, Social Security, address, date of birth. And what they do, they make up wage and withholding information. They claim standard deductions or just a few itemized deductions and maybe a tax credit, and then they produce this tax return that generates a large refund, and they basically sit and wait for the mail to come and deliver their checks. Really easy. Illegal, but easy. So that's a tax refund fraud. And the fact here that the cyber criminal makes up wage, okay, he or she, where is it? Come on. Files the fraudulent return electronically, which technically makes it a cybercrime and not ordinary fraud. Cyber criminals file electronically because W-2s are not included with the electronically filed returns, and by the time the IRS discovers the return does not match up with the actual W-2, the crime is complete and the funds have been absconded. The second one, sorry, I'm making you dizzy here, corporate account takeovers. During the summer of 2008, a different type of cybercrime was identified, and that was corporate account takeover. It's costly and ranks among the fastest and most deadly type of attack. These criminals are engaging in this activity surreptitiously. They obtain an entity's financial banking credentials. They use software to hijack one of its computers remotely and steal funds from the entity's bank account, and this often costing the entity thousands of dollars. They illicitly acquire the login credentials. They covertly gain unauthorized access to the victim's computer to avoid the bank security features, because sometimes banks activate if they don't recognize the login fingerprint, they give you more security. And then they transfer the victim's bank funds to an account controlled by the cyber criminal. Identity theft. I think we've seen enough of that on television, on news reports. But one of my friends recently, she was divorcing from the husband, and the husband's children lived with them, adult children. And when she wasn't there, they opened the mail and there was a credit card, and they took the credit card and signed it and started using it for personal reasons. And it was her credit card, her line of credit, her Social Security number, and her business account. So that would be identity theft. So some examples are opening a line of credit, purchasing goods or services, renting or buying a house or an apartment, receiving medical care, obtaining employment. And fourth is theft of sensitive data, like credit card, unencrypted credit card information that's stored by a business. How about personally identifiable information, trade secrets, the source code, customer information, and employee records? These all attract the attention of cyber criminals. And the last one is theft of intellectual property. One reason you in your academic career need to put APA sightings and your references down is because you won't be stealing intellectual property. Intellectual property includes commercial, copyrighted materials, which includes movies and books and music, and it's also at risk of being stolen. We hear all the time where music owners have arisen because that's the song I wrote. Well, it sounds very similar, but for some reason the person who made it into a hit thinks it was his or hers because they actually wrote it. Well, really, it's because they heard it and they forgot they heard it, and the tune came up naturally. But still, that's theft of intellectual property. And we had that huge case with the downloading of music that had to be stopped a few years ago. So now we have to actually purchase it differently, and we can download it for our own personal use. So this is a very good article. I will go back to the top so you can see the heading. It's the October 2013 edition of this AICPA's publication, and it's called The Top 5 Cyber Crimes. Okay.
Welcome to Fraud Talk, the ACFE's monthly podcast. This is Mandy Moody, the ACFE social media specialist, and today I will be interviewing Jeff Windham. He is a JD and CFE and analyst at Forensic Strategic Solutions in Birmingham, Alabama. And he recently presented on the topic of the top 10 fraud examination legal pitfalls. So welcome, Jeff.
Thank you, Mandy.
And we're, this is kind of a hot topic for us because we always see one of these top 10s or a few of these top 10s in an article, but really we don't ever get them together and break them down all together. So I think this will be good for our listeners to hear kind of everything in one podcast and things that they kind of face every day or face over a period of months when they're working on a case.
Yeah, I think that's right. And I put together these top 10 based on input from other CFEs that I've spoken to and based on examinations that we've done here in our office. And so it's good to have them all together, and it's a good refresher and reminder on what those legal issues are that you may run into.
Yep, wonderful. Okay, well, we will start with number 10, which is admissibility challenges. Tell us a little more about Rule 702 and how that applies and the challenges that may arise.
Rule 702 of the Federal Rules of Civil Procedure is referred to in general as the Daubert Rule and the Daubert Challenge. Daubert instructs the judge that any expert that's going to testify in a matter has to qualify to testify as an expert. They have to qualify by virtue of their knowledge, their skill, their experience, their training, or their education. And that or is very important. You could have 4 of the 5 of those things. You could have 1 of the 5 of those things, and you may still be an expert. The second ones are a little more simple, and that is that the expert's specialized knowledge will help the jury. Third is that the expert's opinions are based on sufficient facts and data. And fourth is a reliability test, and there's 2 prongs to that, and that's whether the expert has used reliable principles and methods, and whether they have applied those principles and methods reliably.
Number 9, searches. And this is actually something that I think, you go into that gray area. Tell us about workplace searches and what examiners need to keep in mind when they're doing searches.
It's a sticky area. The 4th Amendment to the Constitution prohibits a government employer from making unreasonable searches in areas that a reasonable employee would expect to be free from a search. That would include things like a female's purse. That also might be something like a male's wallet. These are things that are personal. There is a control test for workplace searches, and that is whether or not the area being searched or the thing being searched is under the exclusive control of the employee, or is it under the exclusive control of the employer? The female's purse is a great example. Unless in a very rare situation, your firm or office or company buys purses for you.
Yeah. Wouldn't that be nice?
It would be nice, I'm sure. But unless that happens, assuming you have purchased your own purse, that purse is yours, and that purse is off limits to being searched as long as it's not wide open, sitting on a table. Then somebody could peer into it, but they couldn't search it because that's yours. That's totally under your control. The important thing to remember about the searches is the control test. If it's under the control of the employee, if it's something that's personal to them, it's typically off limits. If it's something that is owned by or purchased by the employer, then it's typically okay to be searched.
So the next 2, number 8, number 7. Number 8, employee rights, and number 7, invasion of privacy. Kind of tell me a little bit more about the rights that employees have coming into it, and what to keep in mind, and then you can kind of bridge that with their expectation of privacy.
Sure. Yeah, and these are really important because in large companies, CFEs and risk managers and internal audit people, we have to talk to other employees, and we have to do investigations and interviews at times. But we need to keep in the back of our heads that employees do have some constitutional rights. The most important are the 4th, 5th, and 6th Amendments. As a CFE, if we're investigating or interviewing someone, and all of a sudden, just to give an example, it comes up that this person gets extremely nervous, starts to slow down, doesn't want to talk about anything else, and if we're talking about the 6th Amendment, they may ask for their attorney before they speak anymore. They have the right to stop speaking, and they have the right to get that attorney. That translates into what I've listed as the number 7 legal pitfall for fraud examiners, which is invasion of privacy. And invasion of privacy comes in 2 different flavors. The first is called publicity of private facts. An example of this would be if someone, let's just call him John Doe, climbs up to the top of the ACFE headquarters building with a handheld microphone and decides to to shout out that Jim Smith has some kind of incurable disease. You can fill in the blank. The second form of invasion of privacy is intrusion upon seclusion. And that happens when someone pries into the private matters of another person without a legitimate interest.
So, number 6, malicious prosecution and abuse of power. Give me kind of the lowdown on that and maybe what that might look like.
Yeah, this pops up when an examination usually has been completed. The elements for that are that there was an investigation or there was a proceeding, such as a criminal action, that occurred without just cause. Number 2, with malice, which is an intent to harm the victim. And then number 3, that the proceeding ends favorably to the victim.
But number 5, financial privacy. In your presentation, you mentioned this. Several states have different legislation about this. What is something that examiners need to remember when looking into financial records?
This is one of my favorite ones to talk about. The key is in the law called the Right to Financial Privacy Act of 1978. There's all kinds of material about this out there. You can Google it, you can read it. It's very interesting, but the substance of it is, and what you need to take away from it, is that it prohibits a financial institution, which would include banks, investment firms, those type of entities, from releasing financial records of a customer to a government authority unless the government authority has demonstrated its compliance with procedures regarding confidentiality that are dictated by the statute. We just need to remember that because so many of our investigations and examinations involve financial aspects. We need to remember that we can't just go to a bank or a financial institution and get records on other individuals without going through all of the requirements in the Right to Privacy Act of 1978. And I'll tell you that generally what it comes down to is we oftentimes have to wind up either getting the consent from the person whose financial records you're looking for. That's the easiest way to go. Or number 2, getting a warrant. Mm-hmm. So those are the things to remember about the Right to Financial Privacy Act.
And then number 4, duress. This, I don't know how often this happens, but some examiners, I would imagine, do, investigators, detectives, things like that might experience this more than others, but, kind of speak about how that might play out.
Yeah, Mandy, duress always brings back in my mind thoughts of movies you may have seen with detectives or the police, where they've got a witness in an investigation room, and they lay the witness down on the floor and put the chair over his neck, sit on it, and start asking him questions and demanding that he answer, or he can't get up. And while that makes for great entertainment in the movies and on TV, that's duress. And when a person is under duress, it's defined as a situation where a person is under the threat of violence or other pressure. Now, it can be as simple as just grabbing someone's shoulder and maybe giving it a little squeeze. So we typically, don't want to touch people we're interviewing anyway, but we have to be really careful about that. It can be anything that is offensive or makes somebody feel threatened. It's often claimed by people after the fact when they're presenting a defense to or challenging the validity of statements that they made. So, for example, if I'm interviewing you and we are in a room And I lock the door and I start slamming my fist down on the table and demanding that you answer my questions and, threatening you with force, then I have now put you under duress because you are in fear. And even if you do answer my questions, then later on, let's say you give me a statement. Later on, you're going to be able to say, I was not thinking right at that time. My statements are not valid. They're not good because I was under duress.
So number 3, privileges and work product protection. I think there might be some assumptions that people make about what might be privileged and what might not be. Kind of tell us what those distinctions are.
Yeah, and I address this in 2 ways. One is the attorney-client privilege as it relates to large companies, or it can be small and medium-sized companies too, but we generally think of large companies. And then I also like to talk about it in terms of CFEs who are doing private investigative work and maybe hired by attorneys or maybe hired by any third party. So let me talk first about the way it plays out in companies. And I'm thinking in terms of a large company, but again, a medium or small size company, this would apply to. And that is that business communications within the company, within communications from someone in the company to in-house counsel or maybe outside counsel, but usually you see it in regards to in-house counsel. Communications made by employees to the company's legal counsel are going to be privileged. The second part is, as CFEs, when we are working for attorneys and doing investigations, then we want to be sure to explain clearly what our role is. And one way that our firm does this is through a clause in our engagement letter that says we agree to begin work on this matter as your consultants, and we anticipate that the work we do may be protected by the attorney-client, work product, or other applicable privileges. And what that does is that just sets an agreement between you and the engaging attorney that we're working as a consultant and our work for you is protected by the attorney-client privilege. And then if someone wants to challenge the work that we've done as a CFE for an attorney, then they may have to try and go through the attorney-client privilege, which is not easy to do.
And number 2, this kind of goes back to the interview room, but false imprisonment. You give some tips, in part of the presentation, but kind of tell me what that is. And then those tips that you mentioned, allow witness to sit close to the door, don't lock the door. Kind of tell me more about those.
Sure. False imprisonment is defined as the unlawful detention of a person by another for any length of time whereby she is deprived of his/her personal liberty. This is, like you said, locking someone in an interview room. We don't ever want to do that. We want to put the person as close to the door as we can. What I will do is, before I interview another person, I will actually arrange the chair so that their chair is between me and the door. That makes them closest to the door. That way, if anything comes up, if an issue comes up later, they won't be able to say, yes, he was blocking my exit, okay? And then I always recommend and this is our firm policy as a matter of fact, we always have 2 interviewers, so that if any issue comes up, that we have 2 people there that can verify or testify as to what happens.
And the number 1 fraud examination legal pitfall, defamation. You mentioned, the definition of this, and then there's another case that you bring up Lewis versus Rich. Tell us a little more about that, and then things that fraud examiners need to remember about defamation.
This comes up all the time. We've had cases on this, and I'll tell you about the case that we were involved in just a minute. But let me tell you just generally what the definition is of defamation. And it is that there's an untrue statement of fact published to third parties on an unprivileged occasion, and it's damaging to the subject's reputation. The Lewis versus Rich case that you mentioned, this is a great example of it. Actually happened here in my home state of Alabama in 1982. The facts of the case, Lewis called Rich a thief in the presence of another person. He stated that Rich had stolen money out of his wife's wallet. So Rich says, "No, I didn't. That's wrong. You're lying." Other people had heard this, like it says, in the presence of other people. So Rich sues Lewis for slander, and they gets a jury verdict for $10,000. And $1982, that's a decent amount of money. And it was affirmed. Lewis was unable to defend that statement that he made. Now, one of the defenses to defamation, and this is very important to remember, is that it's true. So if Lewis had called Rich a thief and it was true Rich had stolen money out of Lewis's wife's wallet or pocketbook, then he would have had a defense and the verdict would have gone the other way. He would not have been liable. So truth is always a defense to defamation. Defamation is probably the biggest concern that we face as fraud examiners, and that's why I put it as my number one legal pitfall for fraud examiners.
Awesome. These are some really great tips. Well, thank you very much, Jeff. And we will post all of these.
Well, I thought was a great interview. For the remaining of this time, I would like to have another interview played on tips on how to get a job. I mean, you're going through all this accounting curriculum. Obviously, you want to be an accountant and you want to further your career. So I found this, again, for the fraud examiners, Get Real, Practical Tips for Finding a Job. So we're going to play that for a few minutes and see if you have any questions after that. And if not, we'll continue on for the next week.
Welcome to Fraud Talk, the ACFE's monthly podcast. I'm Mandy Moody, and I would like to welcome LaDonna Wernley today. She is the Director of Human Resources at the ACFE, and today we're going to talk about some practical tips for finding a job. We get asked frequently at the ACFE, online and in person at our events, for recommendations or tips or secrets, how to get a job fast, how to find a job maybe when you're fresh out of college or just upon earning your CFE credential. So I thought it might be a great idea to have LaDonna on. So welcome today, LaDonna.
Thank you.
And let's just dive right in. I think one thing that people get discouraged about is that maybe they're doing something wrong. Maybe, did I miss something on my resume? Did I send an email too fast to check and see how things are going? What is one of the biggest misconceptions that you see or hear about when searching for a job? Is there something you see people do over and over again that maybe could be done differently?
I think one of the biggest misconceptions is that we're holding on to past practices. And those past practices include researching a job board and then automatically sending a cover letter and a resume to random positions or any position that sounds like it might relate to our job skills. Not the most effective way to job search. I think one of the things that is a huge misconception today is that LinkedIn is not a necessity, and it is definitely a necessity in the job search. it is critical that not only do you can absolutely apply for positions, you can absolutely send your cover letter and resume and go the traditional job board route. But in addition to that, a portion of your job search should be committed to finding a contact within the organization that you would like to work. It is critical to have someone that can vouch for you. The majority of jobs, we've said this over and over, the majority of jobs today are filled by referrals. They're not filled by applying to a job board.
So you mentioned LinkedIn as being a necessity, a must-do. How have you seen that landscape change? Because, back when I was applying for a job, that is all you did, was you did a cover letter, you did a resume, and you were done. And I remember I'd send 10 to 15 a day and call it a day. So now you've got LinkedIn, you've got social media, so people can kind of vet you before they even ask you to come in for an interview. So because there's so much information already out there, how do you get an insider? How do you make that contact? Do you reach out to them on LinkedIn? Do you connect with them that way? Do you try to go to an event, a networking event of some sort? How do you make those contacts?
I think all of the above. Reaching out to someone via LinkedIn, sometimes I think you should take a more subtle approach, and maybe you go through your current contact list, people that you know and that can vouch for your work experience and your work product. First, see if you know anyone, past employee, a current employee, or someone who is connected to someone else in that organization, and ask not for them to vouch for you, but for them to either assist you with marketing yourself to the organization and or give you an introduction, someone that might be able to set up an introduction for you. I would peruse my contact list and start that way. Secondly is networking. Face-to-face networking is powerful. Volunteering, networking within a shared community is a powerful way to meet other people from all different types of industries, and someone that can vouch for your character and can vouch for not necessarily your work product, but your character and your commitment to community. All of those areas are ways to network.
Do you recommend, as someone who's looking for a job, would you recommend going after a position or going after a company that you might like? Or do you think people do both?
I think people do both, but I think it also depends on the desperation level. What I see is that when someone is a little bit more desperate to find a position, that they might tend to apply to a variety of positions without truly researching the cultural fit of the company, the proximity to their home, whether or not the job really aligns with their skill set. I think when you are doing a job search and it's on your terms, I think you might move in a direction that is more aligned with the company and do the research on the company and the position. I think when you market yourself, it's critical to market yourself for a position. It's not necessarily because you know your skill set and you know which positions you're going to be successful in.
I think a trend that we've been seeing is the use of a headhunter or a recruiter. I've heard people tell me, I have to get a recruiter, or I have to work with a recruiter. I have to. That's how people are getting jobs now. Can you kind of define what that is? Because for some people, they don't even really know what that is. If they're doing it old school with a cover letter and a resume, why would you even work with a third party? So tell me what that is, and then how important is it to work with one or to make sure they know who you are and build that relationship?
I think the term headhunter and recruiter are used interchangeably. In the past, we saw headhunters that worked for both the employer and headhunters that worked for individuals to help them find and place them within positions. That term headhunter is really outdated. So let's just use the term recruiter. Recruiters work for, the majority of recruiters are contracted with the employers. They're contracted with companies and firms to place individuals in specific positions. I would steer clear of anyone who is going to charge you a fee to find you a job, because they are going to be using the same methodology that you're going to be using. They don't have contracts with employers. Employers normally pay the fees. So if you are being asked as an individual to pay a placement fee, I would steer clear of that. It's not a common practice today. It's important to be connected with recruiting firms if you are on an active job search, to send your resume, to make sure that they know who you are, to link into a variety of different recruiting firms so that you are in their database. Recruiters oftentimes can present you with an opportunity at a time where you're not necessarily looking for a position, but the opportunity really aligns with what your skill set is. They've kept your information available, and oftentimes those opportunities can be great ones. They're not really expected.
So that's news to me about the recruiting. Back when the last time I looked for a job, I didn't really know what a recruiter was or even how to work with one. Another question that comes up pretty frequently with us, and I know that this will sound very familiar to you, because we do require experience even to get our certified fraud examiner credential, is when people are just fresh out of college, or even getting their master's, or they're switching careers, going from accounting to law or vice versa. There's the experience required on a lot of job postings. So how do you get past that, or do you get past that if you don't have the experience yet, but then you need someone to throw you a limb so you can get the experience? And we hear this a lot, especially from our younger members, is I don't have experience, but no one's willing to give me experience. So where do you start with that?
One of the best resumes I've ever seen came from a college student who was looking for an internship. She happened to be the treasurer at one point of her sorority, and under her experience, she put treasurer of XYZ sorority, and she outlined those skills that she used while she was in the position of treasurer. She articulated that she had accounting acumen, bookkeeping acumen, fundraising acumen, project management acumen, all as being a part of the sorority and serving in the role of treasurer. In addition to that, she had volunteer, and she was a volunteer organizer for Habitat for Humanity. And through that, she outlined her recruiting capabilities. She outlined her project management capabilities and her management capabilities, all as part of a volunteer opportunity. So the key is you've got to be able to translate skill sets that employers need within the position, and you have to be able to translate that from your past experience. I've seen resumes where stay-at-home moms have talked about scheduling and organizing and fundraising and volunteer organizing, and all of those are skills that employers want. The key to a resume is not to outline all of your past experience, but it's to give an employer a reason to hire you. So outlining the skills that would be beneficial in their firm is critical.
I think something a lot of people might do as well is, and I did this for a long time when I was younger because I was simply lazy, but is sending the same resume or the same cover letter, the same message on LinkedIn over and over to different companies and different people. And, it took me a while to learn that, Mandy, you need to customize these. These are different roles. These are different people. How important do you think that is?
I don't necessarily think that a resume if the resume really speaks to your skills and your accomplishments, not necessarily your job functions at your past employers, but speaks to the accomplishments in each of your last roles, then I don't think that you need to regularly update your resume. A cover letter is another thing. I'm not going to read your resume if your cover letter didn't catch me, period. What I want to see in your cover letter is a reason to look at your resume. And so your cover letter really is more of it's a billboard. It should be an example of why we should hire you, what you plan to bring to our organization. And ultimately, in finding that in a cover letter, we'll want to take the next step and read your resume.
What is one secret weapon you would give someone who is beginning a job search? What is one thing that they should definitely get right or pull out, or
a rock solid LinkedIn profile? One that has a powerful summary of who you are and what you can offer an organization, that has the entire work history filled out in its entirety with dates, education. There's even a place for special interests. You can, opportunities that you're seeking. The LinkedIn profile is it's a one-click, it's a quick way for an prospective employer to vet you. And the effort that you put into your LinkedIn profile is important. I really foresee the traditional resume and cover letter going away. I foresee we've gotten to a point in our society that you can actually apply for positions with one click of a button on LinkedIn. Apply with your profile. Wow. It's that easy and it's that quick. And if it's that easy for candidates to apply to positions, ultimately it reduces the work on the recruiting side of things, and they're going to be the ones that are going to drive the process. And trust me, no one wants 250 resumes and cover letters in paper form or email format for one position.
What was your first job, and how do you think that job reflects what you do now? How do you think it may have prepared you for your role, if at all? Who knows?
My first job was in the retail industry. I worked for JCPenney in the home fashions department, the home furnishings, home goods.
And how old were you?
I started there 5 days after I turned 16, and I worked there until I was 20. I believe that everybody should have one stint at working with the general public, whether it's in hospitality, food service, retail. Working with the general public gives you an appreciation of working with a diverse customer base, a diverse coworker base. I think that working in retail really prepared me to work with management styles of all sorts of management styles, all sorts of generational, different age groups. But working with the general public, I think, prepared me to do what I do now, and that is work with people from all backgrounds and work in a positive, productive manner.
You were there in college? You stayed? And why did you leave? Was it time?
It was retail. No, I ended up going to a commission-based position because I realized, wow, I can work fewer hours and earn, and be a little bit more in charge of my earning potential. And so I took that opportunity. But continued to work in the retail industry throughout college.
I want to kind of summarize what we talked about. First and foremost, create a LinkedIn profile if you don't already have one, and fill it out completely. Include your photo, your past experience, your past positions, and a quality summary that gives people insight into who you are and what you're about and what you're looking for. Also, use the contacts you have or may have. You may even have contacts you don't know about. Go through your LinkedIn, go through your friends and family, use those contacts and see if there might be connections there that you don't know about, or the ones that you do, and use those to your advantage. And also, we want to remember that when working with a recruiter, it's really important to know that recruiters are most likely working for companies. And it's probably not going to be in your best interest to pay somebody to help you find a job. You have all the tools you need to do that on your own. And lastly, in regards to experience, translate any experience you already have onto paper or onto a screen. As you mentioned, you might have experience somewhere volunteering, or at your church, or as you mentioned, in a sorority. Use those skills that you have gained in those places and communicate them in a way that says, here's what I would bring to a position. Here is how this would work for your company and for that position that I'm applying for. And, we've all had our first jobs. I think we can all learn at least some humility from it and to take that into your role, but also to look at those skills that you first had when you first started out, working with people, working with different types of people. It's just like your neighbors. You don't get to choose your neighbors. You don't get to choose your coworkers, so learning how to navigate through the many different types of personalities that you will meet along the way is probably a priceless skill. So thank you, LaDonna, very much.
Well, I hope this has been an interesting hour for you. We started off with a quick summary of the chapter for chapter 19. We actually paged through the chapter. It's 10 whole pages. And we talked about your fraud case and where to get some information on choosing a fraud case, and telling us how it was discovered and how it could have been prevented. So I look forward to reading your findings on those cases. And it's about an hour now, and I'll say goodbye. But then we had 2 interesting interviews, one on the top 10 items to remember, pitfalls not to fall into when dealing with attorneys as a fraud examiner accountant. And this last one was a public service for me to you as a gift on how to find a job. I really want you to get the job that you really deserve and really want after all your academic endeavors with this college. So I want the best for you all, and I will say goodbye, and I'll see you next week.